Hey guys, today we're going to focus on topic 1.5, the ratification of the United States Constitution. According to College Board, our objective is we're going to explain the ongoing impact of political negotiation and compromise at the Constitutional Convention on the development of the constitutional system. We're going to focus on the following essential knowledge. Compromises deemed necessary for adoption and ratification of the Constitution are represented by the Great Compromise, Electoral College, 3/5 Compromise, and the Compromise on the Importation of Those Enslaved. Debates about self-government during the drafting of the Constitution necessitated the drafting of an amendment process in Article 5 that entailed either a 2/3 of the state legislatures with final ratification determined by 3/4 of the states. The major focus at the constitutional conventions focused on the following debates: the Great Compromise, the Electoral College, the 3/5 Compromise, and the compromise of the importations of those that were enslaved. So in Philadelphia, Pennsylvania, they focused on the Great Compromise. The Great Compromise, also known as the Connecticut Compromise. Those are the same thing. You may see the term Great Compromise, you may see the term the Connecticut Compromise. The compromise was focused on the following two plans: the New Jersey Plan and the Virginia Plan. The New Jersey Plan was a plan that represented those states that were smaller, not just geographically, but based on population. The New Jersey Plan wanted a unicameral legislature with just one house. They wanted each state to have one vote, and they favored states with small populations. The Virginia Plan wanted two houses. They wanted a bicameral legislature. They wanted representation based on population in both houses, and they favored states with large populations. Regardless of the two plans, both of them wanted a stronger national government because they were thinking of the problems created by the Articles of Confederation, and they also recognized the importance of three branches in our government. The Great Compromise led to the following. First, we have a bicameral legislature. Currently, our Congress has a Senate and a House. The Senate has equal representation, meaning every state has the same amount of representatives. Currently, each state is given 2 senators. In the House, representation is based on population, meaning the more people you have in your state, the more representatives you have in the House of Representatives. They focused on that all legislation or all laws must be approved by both chambers. They also agreed that the executive or president can veto legislation. And they also had the key point that the legislative branch, Congress, can also override the veto. So again, the Great Compromise, also known as the Connecticut Compromise. The second debate was the Electoral College. This was also a product of compromise. The question that the Founding Fathers considered was, how should we select the president? They looked at many different ways to figure this out. Should we elect the president based on popular vote, meaning the person that gets the most votes wins? They said no. Should we let Congress decide who the president is? They ultimately said no. They felt that would give Congress too much power. They said, let's let the state legislatures make that decision. And they said no. Was there another way? And ultimately, there was. The answer was that states would each appoint independent electors who would cast the actual ballots for the presidency, the Electoral College. This was a compromise then is different than how the Electoral College works today. Back then, in the initial thought of the Electoral College, it was thought that the electors should be independent in thinking. Now, we have a winner-take-all method, meaning, for example, in the state of Ohio, the candidate that gets the most votes in the state of Ohio gets all of Ohio's electoral votes. So before, there was the initial thought that the independent electors would be more wise than independent voters. And so the Electoral College would act as a buffer between the presidency and the people itself. The third compromise was called the 3/5 Compromise. One of the key questions that Southerners were concerned with was they recognized that they had an institution of slavery in the South. But Southerners also wanted to have more political power, and about 1/3 of Southerners were forcibly enslaved. The question that Southerners had, and Northerners too, was how should this population factor into representation, particularly in the House of Representatives. Remember, the more people you have, the more representatives you get in the House. Obviously, so that the Southern interest was to count those enslaved fully to aid in representation, so you have more representatives in the House, despite the lack of natural right protection for those enslaved. Remember, the Southerners refused to protect the natural rights of those men and women who were enslaved, yet they wanted to utilize their numbers for representation in the House to gain political power. Northerners, who were still generally not that concerned with slavery, even though they knew it was wrong, said that this was something that they were willing to compromise with. 3/5 of enslaved men and women would count for both tax purposes and representation. So Southerners could count those men and women that were enslaved towards membership in the House of Representatives and tax issues, but only 3/5 would be counted. This is the first time where the federal government puts an actual value on the life of a human being. The fourth compromise that is discussed was the compromise on the importation of those that were enslaved. Northerners were generally fine with eliminating slavery, yet they weren't super concerned about fighting a war over it, we should say. Southerners wanted to maintain that system. Southerners came to this debate with a lot more emotion and desire to maintain that institution. Ultimately, when it came to the importation of slaves from other places, particularly in the slave trade, the triangular trade, Northerners agreed to allow the slave trade to continue for 20 more years, but they banned, and also a ban on tax on exported cotton for 20 years. Southerners would allow the majority vote for navigation laws in the House. And lastly, the federal government has the authority to regulate foreign and interstate commerce, and the Senate can ratify treaties with a 2/3 majority. Ultimately, the Founding Fathers thought that slavery was going to go away, so they put a 20-year timeline on that importation of slavery. Yet because the Founding Fathers were unable to make a decision on the issue of slavery in the Constitutional Convention, we ultimately allow it to continue to be an issue, and it leads to the Civil War about 80 years later. The final thing that we want to discuss in this is the formal amendment process. The Founding Fathers recognized that the Constitution isn't going to be perfect, and there's going to be times that you need to either change it or add on to the Constitution. Previously, the Articles of Confederation required way too much to amend. And so the Founding Fathers of the Constitutional Convention wanted to provide more opportunities to amend the Constitution when necessary. There's officially two ways to propose an amendment. First, 2/3 vote of each House and Congress can officially and formally propose an amendment. An amendment does not need a signature from the President as long as it has 2/3 vote from the House and the Senate. The other example that you can propose an amendment is that an amendment is proposed by a national convention called by Congress at the request of 2/3 of state legislatures. All amendments have been proposed through the 2/3 vote of each House of Congress. An amendment has not been proposed through a national convention. The other way, or the next way that you could ratify amendment, meaning to officially add it to the Constitution. The first way that you can ratify an amendment is through 3/4 of state legislatures, meaning 3/4 of the state legislatures in every state has to ratify or approve of that amendment that was proposed. The other method is an amendment is ratified by 3/4 of the state conventions. The Constitution has been officially amended 27 times. 26 amendments have been ratified through state legislatures. Only one amendment has been ratified through conventions, and that's the 21st Amendment. The other item that we need to consider is that there are informal amendments, ways that you can change the way our government works, expectations of government, and those are through the informal means, basic legislation, laws passed by the House and the Senate, signed by the President. Presidents can give executive actions. They can change our expectations for what a president is responsible for by increasing those expectations or decreasing those expectations. There are court decisions. The Supreme Court can make decisions and change interpretations for the Constitution. The way political parties conduct themselves can also change our expectations for the Constitution. And lastly, there are just unwritten laws or norms that govern our Congress and govern the way our federal government works. That presidents, senators, members of the House, the judicial branch, they do things because that's the way they've been done. Yet maybe they're not officially codified in law. So you want to consider and think about the roles of amendments, both formal and informal, within our own Constitution. As we think about these debates in the Constitutional Convention and also future debates, what role did these previous debates and these informal amendments play in those types of debates that we currently have? Next up, you're going to learn more about the specific principles of the Constitution.